Good evening, ladies and gentlemen, and welcome again to another of the Paradise Tea Party Speakers Forums. Tonight we're going to talk about self-defense. But before I begin with my presentation, there's something that I would like to say. Something more I would like to say. Our strength is in our numbers. When we come together in groups like this, it's very clear that we are all good men and women of a common mind with a common cause. And I would like to take just a moment to express my most sincere gratitude to the Paradise Rod and Gun Club for assisting us with this presentation tonight. So if you want to join a quality gun organization, let's give them a hand. Tonight's presentation is what it means to stand your ground in California. This evening's speakers will express their personal opinions concerning matters that may have serious legal consequences. Now, I'm going to say something and I don't want you to head for the doors. You're going to hear from at least 3 attorneys today. We are going to be talking about California gun laws. Please don't leave, but please pay attention. This presentation does not create an attorney-client relationship between any of the guests and any of the speakers. He's immune, he doesn't care. I'm not. The statements made in this presentation are not offered as legal advice. Now, with that said, Mr. Ramsey brought his law books with him tonight, so this is going to be a rather long meeting. Okay. The speakers are not making any guarantee of any particular outcome or result in any particular matter or matters or in any case or course of action. This is why people hate lawyers, by the way. If you are involved in a present or pending legal matter, you are advised to contact competent legal counsel as soon as possible, as certain of your legal rights and remedies may be lost just by the passage of time. And the opinions expressed by the speakers do not necessarily represent the positions or the opinions of the Paradise Tea Party, the Masonic Lodge, or the Republican Party, well, especially the Republican Party.
Yeah. Tell us about it.
However, I do need to warn you, we believe that they should. Okay. So here is a worst-case scenario to consider. It is 3 o'clock in the morning, and visualize this with me. You are home, dead asleep, and your children are safely in bed. You're jolted out of your sleep by the sound of breaking glass, and you reach for, and consider this carefully, what would you rather have within your reach? A telephone? Or a firearm? Well, that's the decision you're confronted with tonight. So before you make that decision, or make the wrong decision, we want you to make sure that you have the best information available, and that's about this evening. So we're going to begin with this question: why all the interest in self-defense and concealed weapons? Well, let's kind of go through a list. Increased crime rates, or at least the perception of increased crime rates. And all you have to do is look at the number of stabbings we've had in Chico in the last 6 months. Home invasion robberies. How about the prisoner release program, releasing felons into our communities under the polite name of realignment? Greater municipal spending on non-essential services. An example of that are called parity raises, where public officials receive raises, department heads, so they can make the same money as somebody in another community. That extra expenditure is leading to budget deficits. Those deficits result in budget cuts and, importantly, cuts to law enforcement. It's my understanding that Paradise has about 60% of the law enforcement that they're recommended to have for this size community. The realization that armed criminals have a substantial advantage over unarmed citizens, and of course the Trayvon Martin and George Zimmerman trial. The District of Columbia versus Heller is a 2008 case decided by the United States Supreme Court. At issue in that case was a gun ban in Washington, D.C. And briefly and summarily, the Supreme Court said that under the Second Amendment of the Constitution, that citizens have the right to keep and bear arms in their homes for their protection. So in the time since that 2008 decision, there have been many studies on how the ability to possess a weapon has affected violent crime. And in one study, for example, in 2007 in the District of Columbia, there were 104 homicides. In 2008, and that is the year of the Heller decision, 107. The very next year, it dropped to 82. 2010, 70. 2011, 62. And in 2012, 51. For a grand total reduction of 52.3% in homicides in the District of Columbia. Gun ownership for self-protection is not only a viable option, but in our communities today, it may be the most prudent decision. In one study in 2006, the folks looked at the violent crime rate in the United States. In 2006, the crime rate was 473.5 incidents per 100,000 inhabitants. They then looked at states that had a shall issue statute that meant that the state had to issue concealed weapons permits, and the crime rate dropped to 400.96 per 100,000. They then went to the other extreme and looked at states that had a restricted issue or did not have a right to carry a concealed weapon, and the crime rate jumped to 542.62 per 100,000 inhabitants. With that, between high and low, there's a difference of 141.6 violent crimes per 100,000 and over a 35% increase. So the statistics are telling us that having the ability to have weapons for self-defense is beneficial in our communities. Tonight, our speakers are going to talk about the use of lethal force, Florida's Stand Your Ground law, California's Castle Doctrine, and carrying a concealed weapon in Butte County. Before we do that, though, it's our policy to inform the people who attend our shows, so we're going to give you some facts and some stats about gun control, not only in California, but in the United States. Number one, there is a difference between California's Castle Doctrine and Florida's Stand Your Ground law. And here it is. Unlike California, the Florida law creates statutory immunity against criminal prosecution and civil liability if there's a shooting in self-defense. Number two, George Zimmerman did not rely on the Stand Your Ground law in his defense for his shooting of Trayvon Martin. He was acquitted because the shooting was justified as being in self-defense, and District Attorney Ramsey is going to talk more about that. Looking at a map of the United States, there are now 21 states that have adopted statutes very similar or identical to the Florida Stand Your Ground law. And California is not one of them. 3, law enforcement personnel are generally supportive of the right to carry a concealed weapon and resistant to further gun control. In March of 2013, a survey was conducted by PoliceOne.com. 15,000 verified law enforcement personnel from across the United States participated in that survey, and 70% of the respondents were field-level law enforcers, so boots on the ground folks who were facing that violence every single day. So in a series of their questions, there were about 30 questions in the survey, and I selected several that I thought were very telling. Question 6 was, do you think a federal ban on the manufacture and sale of ammunition magazines that hold more than 10 rounds would reduce violent crime? A resounding 95.7% of those surveyed said no. Question 22, what would help most in preventing large-scale shootings in public? There were a lot of options given and some pretty good ideas, but the one that received 28.8% more than any other option was more permissive carry policies. There, question 5. What effect do you think a federal ban on manufacture and sale of semi-automatic firearms, termed by some as, quote, assault weapons, close quote, would have on reducing violent crime? And 71% said none. Question 15. What is your opinion of some law enforcement leaders' public statements that they would not enforce more restrictive gun laws in their jurisdictions, taking together both the favorable and the very favorable answers? 71%. So it was favorable. And lastly, question 24, do you support Army teachers and or school administrators who volunteer to carry at their schools? So of the 4 questions, the one that received 76.6% said yes if they're trained. Number 4, the media. Gun control groups and the entertainment industry circulate the myth that all guns are required to be registered either under state or federal law. That is not true. The fact is that gun registration is required in only 4 cities, DC, Chicago, Omaha, and Clark County, Nevada. 3 states, California, Michigan, and Hawaii. And only DC, Chicago, and Hawaii register long guns. Looking at a map of the United States, the yellow states do not require registration. And I would point out that California, which is part purple and part orange, is the only state in our union that requires registration of both handguns and, quote, assault weapons, close quote. Number 5, the right to carry a concealed weapon in California differs by county. That is correct. And looking to a map of the state of California and pointing to Butte County is a real issue for personal protection. And I expect Sheriff Smith to talk about that at length. So should you elect to use a firearm for self-defense, whether carried on your person or safely stored in your home or your business, we would ask tonight that you learn to use your firearm proficiently, safely, and responsibly. That you learn how, when, and where you may carry that weapon. That you obtain accurate information and make your decisions in an informed and reasonable manner. And understand your civil and criminal liability if and when you use your firearm. And remember that gun control means hitting what you aim at. Our first speaker tonight is Michael L. Ramsey. I'm going to pull out my glasses for this. Mr. Ramsey is the Butte County District Attorney, and he has been for over 26 years, and he's been a prosecutor for 35 years. He's a 4th generation Butte County resident, graduating from Orville High School in 1966.
Really old.
They're around like what? Are you like the longest-standing DA in the state? Second. Wow, that's quite a compliment. Mike then attended the University of California at Berkeley. He came home during the summers to log and work in a cannery. After graduating, he worked briefly as a teacher in Oroville and then as a reporter of the Oroville Mercury Register assigned to the court beat. Electing to become an attorney, he then attended the University of Pacific Majority School of Law. Mike was sworn in as an attorney in 1977, the year he graduated, which means he only took the bar once. He then worked in the Sacramento District Attorney's Office and was able to return to the Butte County to work with the Butte County District Attorney. He worked his way through the ranks from a Deputy District Attorney to a Chief Deputy. In 1987, Mike was appointed District Attorney, and he has been elected and re-elected 6 times. As a trial attorney, he has conducted hundreds of court and jury trials with simple assault, from simple assault to death penalty murder. Mike brings a unique quality to Butte County, having lived and worked here for most of his life. He has a love and respect of our community, as well as a history of working to protect and serve all Butte County citizens, regardless of their age, race, gender, sexual orientation, religion, social, or economic status. He has dedicated his career and the resources of his office to make sure that justice is done. No matter who the offender or victim may be, everyone deserves to be protected from the criminal element, just as everyone deserves to have their constitutional rights protected. Mike believes in holding people responsible for their actions, and I think we need to send Mike to Washington. Mr. Ramsey.
Thank you, Ben. And it's interesting, right at the beginning, all of the disclaimers that Ben, of course, gave to you. Lawyers in private practice are required, in a sense, to do that, just like you see on the prescription ads on TV. You know, it's a great drug, but it may cause hives, it may cause itching, and it may kill you. Maybe a parallel with lawyers. But the first thing, we had our veterans stand up, but let's have that great category of Americans stand up. Let's have all the lawyers in the room stand up.
So now we're a target.
Well, you do know.
And I'm sitting in the middle of it.
And you do know that all lawyers are buried 8 feet down rather than the normal 6 feet. Does anyone know why? Because basically, deep down, lawyers are good people. And you did see the books that I brought. That's actually just a prop, because we talked about weapons, and we will be talking about weapons. And folks, that's the lawyer's choice of weapon, all of those books. And then we can get into the philosophy. Which is stronger, or which is more powerful? An AK-47 or this? You know, in some senses, it's this in 1976 that saved our Second Amendment rights, and the U.S. Supreme Court recently saved Second Amendment rights for you to bear and keep arms. But what does it mean, as Ben is going to let us up to bear, keep those arms, and if the unfortunate thing happens, to use that weapon rather than using the phone? And it's interesting because this topic, of course, last year came up and came to the fore in a lot of media in the Trayvon Martin case. And it was fascinating as I was watching CNN and the various shows, the various media shows and nightly news, that they were talking about stand your ground as if this was something very new or very unique. And I was fascinated. I saw very little, in fact I saw none, except one local broadcast that I did that talked about California and California's own stand your law, or stand your ground law. Because California, since its inception, has had a stand your ground law. It's not a statutory law as Florida is, but the history of the stand your ground law actually goes back many, many years ago in a determination among the various states as to whether or not a state would have a stand your ground self-defense law or a back to the wall self-defense law. And basically it was divided by the Mississippi. All of those states to the east of the Mississippi had a back to your wall case law, decisions, and statute that basically said before you can exercise your right of self-defense, you must retreat until you can retreat no longer. Back to the wall. The western states, west of the Mississippi, California included, developed their case law. And when we say case law, we also talk about common law. That's law that is developed by the courts, usually the appellate courts. Those courts that are, and judges that are, in a sense, making law absent the statutes or interpreting statutes. But without the statute, California courts, Supreme Court, said no, to exercise your right of self-defense, you can stand where you are and not have to retreat. In fact, California went kind of one step beyond. You not only have within California's common law, case law decisions in this area, the right, and we'll talk about that, the right to stand your ground, you could actually pursue your assailant until such time as the danger is neutralized. But now where do we find, how do the practicality of what we do with this law, where does it come up? How does it come up in a case? How many of you here, just show of hands, have sat on a jury? Quite a few, okay? How many have sat on a criminal jury? Again, a lot of folks. Well, you may be familiar. You probably saw this set of books on either the defense or the prosecution table. This set of books, 2 volumes that kind of summarizes all of the various California statutes and case law and so forth on the jury instructions. These are the California criminal jury instructions in here. And remember that when you were on that jury and you listened to all of the evidence and you heard the heroic prosecutor tell you what the true facts were, and the whiny defense attorney tried to twist the facts in another direction, that at the end of the case, the judge would read you the jury instructions, the law that you must apply to the case, the facts that were before you. And what I'm going to do is basically read to you what the general law of self-defense, and particularly California's stand your ground law, means when you, let's say you're a person and you've shot someone. You may be a defendant. And there's that old saying, I'd rather be tried by 12 than carried by 6. Well, the 12 that are going to try you, that are going to make a decision as to whether you go free or you possibly go to prison for the rest of your life, will be read this jury instruction. It says the defendant is not guilty of murder or manslaughter or attempted murder if he or she was justified in the killing of someone in self-defense. It also applies to defense of another, your children, your wife. The defendant, you, acted in lawful self-defense or defense of another if, and these are the elements, the defendant reasonably believed that he or she was in imminent danger of being killed or suffering great bodily injury, or was in imminent danger of being raped, maimed, or robbed. 2, the defendant reasonably believed that the immediate use of deadly force was necessary to defend against that danger. And 3, the defendant used no more force than what was reasonably necessary to defend against that danger. Now, belief in future harm. I thought that guy might go home and get something and come back, so I did a little peremptory strike on him. Doesn't work. It says belief in future harm is not sufficient, no matter how great or how likely the harm is believed to be. The defendant must have believed there was imminent danger of death or great bodily injury to himself or herself. The defendant's belief must have been reasonable. Can't make things up. And he or she must have acted only because of that belief. The defendant is only entitled to use that amount of force that is a reasonable person would believe is necessary in the same situation. You notice that reasonable, 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 that's the 12 people. That's the mythical reasonable person is actually an amalgam of the 12 minds that are sitting in that jury box. If the defendant used more force than what was reasonable, the killing or attempted killing was not justified. When deciding whether the defendant's beliefs were reasonable, consider all the circumstances as they are known to and appear to the defendant, and consider whether a reasonable person in a similar situation with similar knowledge would have so believed. If the defendant's beliefs were reasonable, which can't believe that this person is an alien and is about to pull their ray gun on you, because mental defense is not allowed in this self-defense, the danger does not need to actually existed. And that's interesting, and many times you see, and it was just last night I was watching on the news, where a young man, I believe he was a teenager, was killed because he had a replica AK-47. And I've seen on the news they have a real AK-47 and this toy AK-47. Quite frankly, you had to wait until the newscaster said it's the one on the left is the real one. So if someone has a reasonable belief that what they see in that person's hand is actually a weapon that would give great bodily injury or death, they can act on that reasonable belief even if that particular weapon was fake or not a weapon at all. There's been many instances in which, unfortunately, people running from the police have, and quite frankly, one was on a chase up to the Paradise area, in which a young man being chased in his car and wanting to commit suicide by cop, took his wallet out as he was driving, took it out the window, and was doing this. To the officer behind, it looked like, at first, it was a gun, and that officer would have been justified in taking deadly force. Luckily, it was an experienced officer. He saw what was going on, and it wasn't until the young man crashed his car into the gas station and then came out and pretended he had a gun that the officer had to, unfortunately, use deadly force. But what's in your mind as the defendant is important. What's in your mind as to what is the assailant's history is important. If you know this person, because it's perhaps a relative, and as the old saying goes, we can pick our friends but not our relatives, and we know this particular relative is a little off their rocker, and it's a dangerous relative, that this is a more dangerous person than just an ordinary person, and you can use that, or defendant can use that information to make a decision as to whether it is reasonable to use deadly force. A defendant, and this is California's stand your ground law, and this is the law that is read to the jurors. A defendant is not required to retreat. He or she is entitled to stand his or her ground and defend himself or herself, and if reasonably necessary, to pursue an assailant until the danger of death or great bodily injury has passed. This is so even if safety could have been achieved by retreating. And Great bodily injury, and you've heard this all through this, it's great bodily injury means significant or substantial physical injury. It is an injury that is greater than minor or moderate harm. That means that if it's I won't say it's a fair fight, but someone attacks you with fists, and it is not a situation in which you are fearing great bodily injury, because the assailant is smaller, same size as you are, or you're a lot meaner than the assailant, and you are not fearing great bodily injury, you do not have the right, and you would be convicted if you pulled a gun and shot that person dead. So, it's again, what is reasonable, what is not excessive force that allows the person to assert this defense. And then, the last paragraph of self-defense is the one that drives all prosecutors a little buggy. And this is, the people, in other words, the prosecution, have the burden of proving beyond a reasonable doubt that the killing or attempted killing was not justified. If the people have not met this burden, you must find the defendant not guilty of the murder, manslaughter, or attempted murder. In other words, this is called a self-defense is a defense, and we call it an affirmative defense. It is up to the defendant to raise the defense. Once raised, no matter how kind of weak that defense may be, it is then up to the prosecutor then to prove beyond a reasonable doubt that that right of self-defense does not exist. And any time that we are examining a homicide in which there is the possibility of a self-defense, most investigators and investigators with various agencies, particularly the Sheriff's Office, knows to explore this within those particular elements, to check with the defendant to see whether or not that particular defendant's grasp of the facts, that particular defendant's view of the facts are honest and reasonable. And that's the conjunction, honest and reasonable. Now, California, in addition to its stand the ground or stand and pursue, additionally has what we call the castle doctrine. And remember what we talk about, imminent fear of great bodily injury or death. And that can always be somewhat fuzzy. And that can be a situation in which, well, it may be imminent in this situation, it may not be imminent in that situation. Guy's running away, and he's got his back to you, and you shoot him in the back. Was that imminent or not? If he was running to his car, which was right there, and you had a reasonable belief, quite possibly because you knew your crazy uncle, that that person was running for a gun. You're going to have to articulate that. He was running for a gun. So the imminency, the imminent fear at that point would still allow you to exercise that right of self-defense. And the fact that you shot him in the back may be unfortunate, particularly for the person that's dead, but it may save you. But California has another doctrine, and we call it the castle doctrine. It's another layer of self-defense. And that layer of self-defense talks about, you know, the stand your ground and the defense outside of your home. But if something happens inside your home, your castle, then there's another layer of self-defense that the prosecution would have to pierce, the prosecution would have to overcome for a conviction. And that law would be read to the jurors by the judge. It says, the law presumes that the defendant reasonably feared imminent death or great bodily injury to himself or herself or a member of his or her family or household if, one, an intruder unlawfully and, important conjunction, and forcibly entered or was entering the defendant's home, and two, the defendant knew or reasonably believed that an intruder unlawfully and forcibly entered or was entering the defendant's home. Three, and that's an and, the intruder was not a member of the defendant's household or family. Kind of cuts out crazy Uncle Joe. And four, the defendant used force intended to or likely to cause death or great bodily injury to the defendant or to the intruder inside the home. And talks again about what great bodily injury is, not minor injury. Not that this person is a 14-year-old inside of your home with nothing more than a stick. You may reasonably, however, say that that 14-year-old has broken into your home and you are in reasonable fear. And again, it's going to be 12 people that's going to make that decision. And then it's the people have the burden of overcoming this presumption. This means the people must prove that the defendant did not have a reasonable fear of imminent death or injury to any member of his or her family when he or she used force against the intruder. People don't meet that burden, then the person goes free. Won't go into, there's, well, I will go into just a little bit, but understand there's lots of exceptions here. You can't be in a mutual fight and then say, okay, I'm losing the fight, so now I'm going to pull the gun and shoot the person. That doesn't work. Under California law, under our stand the ground, under our rule of self-defense, the person before exercising reasonable self-defense must tap out, is the word, must say, I am done. It's over. I'm moving away. And if the assailant that you started the fight with, that you started the fight, or was a mutual fight that had started, then continues the assault, and you believe you are in imminent danger of great bodily harm or death, then you can exercise deadly force. But understand, that's going to be an issue that will probably come out in the court. And it's going to be these gentlemen behind me that, quite frankly, on any situation in which someone kills another person, unless it is absolutely clear that self-defense has been exercised, you will go to jail. And it will come to me, and we will talk about it with the sheriff's office or the law enforcement agency to make a decision as to whether we feel that we can overcome the claim of self-defense. There have been many cases in which we felt that the person was guilty of the crime of murder, but we could not overcome the self-defense. We felt that perhaps the self-defense was a feigned self-defense. It was a false self-defense. But there's an old saying that, we can believe, and when I say we, the prosecution and law enforcement can believe a lot of stuff. But unless we have evidence to show that stuff, the person should not be in court. And that's a standard, and just as a Crim Law 101, when we talk about the agencies will arrest when that person has shot another person, because they arrest on what is probable cause, and we consider the affirmative defense of self-defense later. And it is then my office's job to look at that and make a decision as to whether that is a self-defense that we can overcome or not beyond a reasonable doubt. And that's a fairly high burden and an appropriate burden. And we talk about the whining defense attorneys and the horrific prosecutors. We try not to be the whiners when it comes to this. We prove it. We're going to be the folks that believe in it prior to coming into court. I'm going to turn it over to the sheriff and his lawyer, undersheriff. But one of the things, and there'll be lots of questions later, but let me give a little warning. There'll be lots of probably, well, what if at 3 in the morning I hear a crash outside, and this and this and this and this and this? The answer is going to be, well, it depends. And that's the lawyer-like answer, because we won't know until we get all of the evidence in. And usually the little bits of evidence isn't sufficient. So this is an area just ripe with landmines, and the responsible use of our Second Amendment rights is what will be discussed now. Thank you.